So I took this opportunity to look at the asylum system, Israeli asylum system, through the lenses of security. And I must say that I don't think this is the main or the biggest problem of our asylum system, as this is an asylum system that continuously produces a recognition rate of less than 1% every year. And I think that the reasons for that are complex and probably beyond the scope of my talk today. But I think when trying to look at the security considerations and their impact on the reception of asylum seekers, of the quality of the decisions which are made, and even the exclusion of people altogether from the system, you'd see that security issues are very much there. But I think, as Professor Karlovsky said, it's a question of how you define what is a security consideration, and in the Israeli context, it's very fluid and very elusive term. So I thought I would just give you brief 3 examples of how security came up. And I think my first example is the treatment of Sudanese asylum seekers, which started arriving into Israel in growing numbers since 2005. And when they started arriving, Israel's immediate reaction was to detain all of them as undocumented arrivals. And our law, this is a 1952 entry to Israel law, provides for the detention of a person who arrived without permit, but this is only allowed pending this person's deportation. And very soon it was very evident that those people cannot be deported anywhere, and then came up the question of how or why they are continued to be held in detention. And the law allows the authority to refrain from release if the person may endanger public or state security. And it was interesting that at the time, the government just declared that every Sudanese national, being an enemy national, is presumed to be dangerous to state security. And we even, in our jargon of every day, we call it the presumption of dangerousness. And this is how everyone related to the issue of whether or not a Sudanese national would be kept in detention. And I remember that at the time, we struggled to understand why Sudan was actually an enemy country. And someone dug it up and found that in 1948, Sudan declared war against Israel, and this was never formally revoked. But it was a question for us: who decides what is an enemy country, based on what criteria? Can this be even challenged? And this had a very immediate impact, because people were placed in detention and could not be released for years on end, actually. And we challenged this detention in administrative tribunals and in the administrative court. And it was interesting that the state held on to that presumption of dangerousness. So the argument was actually that the government came forth and said, we don't know who is and who is not a danger to state security. It was interesting, they said, unlike the Palestinians, whom we have a good grip on what's going on and about who is dangerous and who's not. But those people arrived with nothing to our borders, no way to know if this is actually, as was mentioned here, a bona fide refugee from Darfur or someone who is coming to be a terrorist. Another issue that was raised was that those people were coming into Israel using the smuggling routes that were also used for smuggling ammunition. Therefore, again, there is a presumption that they may be dangerous. And the courts played along. The principle of personal liability was totally abandoned. And even when finally, after about a year and a half, the courts pressed for the release, the fact that the person was defined as an enemy national caused for very, very limiting conditions to be set as a precondition for the release. And I have no doubt that even at those early times, this was the beginning of the arrival of the so-called, infiltrators into Israel. And note the term infiltrators. This is taken from a security-based 1954 security law, the anti-infiltration into Israel. And historically, infiltrators were usually We called them at that time Fida'in. Normally it was Palestinians who, driven out of their lands, were either trying to come back to their fields and cultivate them, or sometimes coming in for terror reasons. But if we are talking about discourse, the actual usage of the word infiltrator, which carries a very negative meaning, this would be a saboteur. So, as I'm saying, even in those very early times, the beginning of their arrival, I'm 100% sure that the government has known who those newcomers were. There were mainly people from Darfur or South Sudanese seeking asylum. And the detention was used to deter newcomers. And so in informal settings, government officials would say that if we would allow those people to come, and if we would allow them to be released, and to work, God forbid, in Israel, that would create a pull factor. So many, many more would come. So the government was saying that there's even a camp that they took aerial photos in Sinai of millions of Sudanese just awaiting to come and flood this the country, and that was actually the danger. So what you see is that even long before 2012, when Israel actually amends the anti-infiltration law to allow for mandatory detention of infiltrators, Israel was already engaging in using detention as a form of deterrence from people to arrive, and that the detention was then justified by actually a non-existent security concern. My second example has to do with the actual decision maker in the asylum process. So it's interesting to see that although the asylum regulations have evolved since 2001, one clause has been there and is intact, and this is Article 10, entitled Subject of Enemy Hostile States. And I'll just read it to you. The State of Israel reserves the rights not to absorb into Israel and not to grant permit to stay in Israel to subjects of enemy or hostile states. And here you see, as determined from time to time by the authorized authorities, and so long as they have the status, and the question of their release and bond will be considered on a case-by-case basis, blah, blah, blah. And then Israel appreciates the UNHCR's notice, according to which, until a comprehensive political settlement is reached in our region, it will make every effort to find those refugees asylum in other countries. So this was the idea which I think was the basis of Israel's consent to actually start applying the Refugee Convention. So the idea was, we will not, under any circumstances, provide for asylum or the right to integrate people who are from enemy or hostile countries. Those people would preferably be held in detention, and UNHCR would take, how do you say, this chestnut out of the fire and would disperse those unwanted people by Israel into other countries. And I must say that for some years, this arrangement had worked, and I think that until 2005, as far as I know, UNHCR had resettled outside of Israel approximately 50 Iraqis and Sudanese who arrived into Israel. This fell apart at the beginning of 2005, when more and more Sudanese started arriving into Israel, and the resettlement capacity is simply not there. And of course, Article 10 contravenes Article 3 of the Refugee Convention, which prohibits discrimination of any kind between asylum seekers, and specifically the convention state on the grounds of country of origin. But of course, who cares? And then Israel continuously and repeatedly argues that the mere fact that an enemy national has crossed the border into Israel would not be sufficient ground for asylum. So the fear is that the person, say, from Syria comes into Israel and then says, just by the fact that I crossed into Israel and I sought asylum in Israel, I cannot go back now. I will be deemed to be a traitor or collaborator and so on. And I think there can be some merit in that argument, but Israel has expanded that to any enemy national arriving into Israel for any reason. So say you are Darfurian and you are fleeing a genocide in your country, Israel is resistant to providing asylum for those Darfurians. And this issue of creating an unwanted pull factor from adjacent country is also demonstrated in similar cases. For example, women victims of domestic violence or threat of honor killing, or gay men who flee to Israel seeking protection. And one of my clients was an Egyptian woman, and initially the government replied that she is an enemy national. And we wrote back and we reminded our colleagues in the state that there's a peace agreement. And then they said, well, it's not an enemy state, it's, they said, an examination state. I'm not sure I understand that, that term. Then they argued that maybe she's a Palestinian and she may be excluded altogether. And finally, when we petitioned to the court and push came to shove, the government said, okay, we will grant her a humanitarian status. And I think this is something that has happened repeatedly since, and is happening today with the Darfurians. The government resists any possible potential of creating a precedent according to which others may come and say we are in similar circumstances and we are entitled to asylum. Humanitarian, charitable gesture, that is okay with the government. And what we were told when we were litigating the case of this woman is that Israel is sadly surrounded by many countries where there are patriarchal norms, and if we will allow this one woman to come, then we will have women from Egypt and from Syria and from Sudan, and of course we cannot have that. And I must say that this is, you know, this floodgates argument is not new in refugee law, and other courts all over the world have dealt with that, and I think there are also some research shows that even if you acknowledge gender-based violence, you are not overrun by hordes of women fleeing this sort of persecution. Our Supreme Court is not impressed with all that. And there is at least one short case, and this was not a case of a sort of an enemy national. It was a woman from Nigeria fleeing domestic violence, and at the time our former Chief Justice Brunis is saying that if Israel will allow such application of women fleeing domestic violence, then Israel will be again overrun by unknown number of women seeking asylum. So to summarize this point, the Israeli authorities are willing to go to a great lengths to avoid granting asylum to persons defined, and note that this is just based on the nationality as enemy nationals. I do not know of one case where the government has gone into the trouble of trying to ascertain individually if a person carries a security risk. My clients used to sit for over a year and a half in detention. Never they have been interviewed by a representative of the security forces. And I mentioned the issue of Darfurians because I don't know how many of you are aware, but recently again, due to court pressure, the government has granted again, humanitarian status to several hundred Darfurians. And this again, I think is very telling. First, we see that a Sudanese national possibly is not so dangerous because when the government wants, suddenly they can provide this humanitarian status. But on the other hand, as I said before, providing humanitarian status, again in the Israeli context, is a way to get away with not providing asylum. And finally, to my third example, some who are considered enemies are excluded altogether from even asking for asylum. And this relates mostly to Palestinian asylum seekers and potentially to nationals from the 4 countries enumerated in our 2003 Entry to Israel and Citizenship Law. Those countries are Iran, Syria, Lebanon, and Iraq. And this law, which probably would be mentioned later, excludes Palestinians and people from those countries from status in Israel, except in very, very narrow exceptions. And we've been representing for over a decade Palestinian asylum seekers, mainly gay men and women fleeing domestic violence or threats of honor killing. And in none of those cases we were successful. When we try to file asylum application, we get back a letter that, based on 1D to the Refugee Convention, any Palestinian is excluded from the 1951 Convention. I don't want to go into great lengths, but this sort of interpretation is contrary first to the language of the convention, to UNHCR guidelines, to jurisprudence all over the world. But Israeli courts are willing to accept this sort of reasoning and saying that Israel has unique problems and unique conditions, and therefore there is some reasonableness. That's the first time that I learned that interpretation of the law can be reasonable. You know, normally either it's legal or not legal. And the court allowed it. And when we come to the Supreme Court, again, and I think that will go back to the keynote tonight, surprisingly, the Supreme Court does not want to pick up the legal issue. So there are all sorts of patchwork of practical, temporary solutions for Palestinians who are not to return if they are arguing for danger, but they will not receive asylum. So where does all this leave us? I think first is just to say that, as was mentioned at the beginning of Professor's talk, security considerations is anything that the government would say is security. And in Israel, you do not have to be individually dangerous or a terrorist for that matter, or even suspect of terrorism. What the government uses is flat bans. It's just all Sudanese, all Palestinians, all Iranians. And basic rights such as detention or even the right to asylum can be violated just based on this sort of presumption, which is non-rebuttable, because if I'm Sudanese, I cannot rebut that. The danger is constituted just by the mere presence of the person of a certain nationality or certain identity in Israel, and what normally would be acknowledged as migration consideration and the fear of poor factor and number and so on. For Israel, this is a security issue. The demographic concern is a security issue. And with the Sudanese, it was very compatible. The people who we are afraid of are those young, male Muslims. And I don't want to go again. International law would say this is wrong. You cannot attribute danger just based on your own nationality. And I think for me, the big question is how come the Supreme Court and the other courts are failing to stop this sort of system? By now, it is already even entrenched in the law. I think the one positive exception to that was when it was the issue of detention. In the Adam and Geber Selassie cases, that's when the court moved and said, you cannot just detain infiltrators for 3 years just for arriving into Israel. But when it comes to actually providing status or allowing to stay in Israel, that's where the court defers to the government and to this idea that enemy national is very dangerous.